Aloya Roland.
Good afternoon. I'm Jack Morgan. I'm a senior partner here at Aloya Roland, and I'm sitting with Scott Hertz. Scott is an attorney in our office. He also happens to be a general contractor and a realtor. We're discussing the bill, Senate Bill 76, that's been recently introduced in Florida by Senator Jeff Brandes out of Pinellas County. That bill is focused on, if you will, reducing payments to consumers on property damage claims, meaning that it seeks to reduce the amount of money that an insurance company would have to pay on a property claim for a consumer after a hurricane. It reduces as well the amount of time that a consumer would have to make a claim, and reduces or limits their access to the court system by limiting attorney fee provisions that have been in place for 60 years. The thought of this bill coming into play in 2021, after coming out of 2020, where people are out of jobs, people have lost businesses, homes, the most active hurricane season in history with 31 storms, it seems inconceivable at this point. But I want to turn it over to Scott and get his thoughts on it from his view.
Well, one of the things I was particularly concerned about in looking at the bill was it enables them to insurers to put a schedule in their insurance policies that I think will be somewhat harder for consumers to understand the full impact of. One of those things is it does provide for full replacement coverage for any roof that is less than 10 years old. But then you move to tile roofs, which are one of the most common types of roofs, particularly here in Southwest Florida, where our law firm is. And it says that 40% for a concrete tile roof. So they could limit the payment to 40% of the value of a concrete tile roof.
And that's after 10 years, right?
After 10 years.
For a roof that lasts how long?
30 to 50 years for a concrete tile roof.
Am I correct too, Scott, that it limits what the insurance company has to pay from a replacement value? In other words, if a hurricane blows my roof off, they have to replace that roof, to an actual value type of evaluation, where if my roof is 10 years old, they would have to replace it at the actual value versus replacement value.
Well, correct. It's more of them giving you the payment and associated with what the current value or worth of the roof is, as opposed to, as you just said, the replacement cost. And a better way to explain that is, if it would cost you $50,000 to replace this roof, but they say because your roof is 11 years old, it's only worth $15,000, homeowner would have to come up with the difference between the cost to replace the roof and what the insurance company gave them. And certainly the premiums won't make up for that.
So assuming that the insurance company evaluates the cost for the replacement of the roof, I still have to come up with 60% of that cost.
Correct.
Right? Okay. Well, what else did you see in the bill that kind of concerns you from both a general contractor standpoint and a lawyer?
One of the other things I didn't see is certainly any direct linkage between the reduction in payments and a reduction in the premiums that folks are going to pay. And certainly based on past experiences with these types of, they call them reforms that are brought forward by the insurance companies. Certainly doctors in the medical industry experienced this with claims for malpractice tort reform, they called it. They didn't see their premiums go down. In fact, their premiums went up. But if you just look at the cost of a tile roof, if you just arbitrarily said that a tile roof on a mid to upper end home here in Southwest Florida was going to cost $60,000, and you only get 40% of that $60,000, right? Is there any way that you're going to save the remainder of that difference in your premiums? How many years of premiums would that be?
So in other words, I'm going to be paying at least the same premium that I've been paying, probably more at some point, but I'm going to get less coverage.
Correct. That would be our concern in looking at this, because historically we have not seen premiums go down after these types of bills are passed.
Scott, what also concerns me is, as I read this bill, there's a limitation on the number of years that a person can make a claim that would be related to a roof leak that leak might be related to some type of wind damage or hurricane. Does that strike you as something that would be relevant to you as a general contractor?
Absolutely. That's what we're seeing now. And in fact, Irma occurred in 2017. And often it took a year and a half to 2 years before people even discovered that the leaks had occurred or that they were experiencing leaks in their roofs as a result of Irma. It takes time for both the impact of the wind effect on a shingle or tile roof to have affected it to where the leaks start. And then by the nature of the fact that the water has to come through the roof, through the wood sheathing, and what it does over time is damage and rots that to where it starts leaking into the interior of the home. Then most homes here have attics that are insulated. So the time it gets through the insulation into their drywall ceiling where they first see a water spot, it can take a while for that to show up. And under this bill, it's possible that by the time homeowners realize that they had damage from a windstorm event, it could be too late for them to make an insurance claim.
Which would result in what?
The homeowner would be solely responsible for replacing the roof, and the insurance they've been paying for would not provide them any relief.
Right. The other thing that bothers me a little bit about the bill, I mean, there's several things obviously, but there has been in place for the last 60 years some protection for consumers who are wholly denied any type of recovery by their insurance companies. And that is that they've been given access to the court system through a statute that permits them to recover their attorney's fees. I think that the importance of that is if I'm an average homeowner and I have to sue my insurance company, a billion-dollar company, my ability to do that on my own is far less, right? If I have to shell out the money for attorney, we're expensive. I mean, let's be honest, we're expensive. Litigation is expensive, and I think it incentivizes insurance companies to delay litigation as long as possible and perhaps hope that the insured or the homeowner gives up at some point. Do you agree?
Well, I would say not just delay, but actually extend. I think there's an incentive there to do that because it takes away the contingency aspect of it. What the bill actually says is that contingency multipliers, where an attorney could recover more than what their normal hourly rate was, is essentially prohibited under this bill. That only by showing extraordinary circumstances that there was no other attorney available that would take this case could you do that. Well, certainly you have to understand, although attorneys do a fine job, every attorney does not win every case. And so the contingency multiplier addresses the risk of an attorney taking on a case where they're not getting paid by the homeowner for that. And there's a balance between the ones they win and the ones they lose that addresses that issue. This bill would take that away and make it much more difficult for a homeowner to find an attorney willing to take their case on contingency.
And why would they? Because, looking at litigation that can last 18 months and 2 years, coming out of COVID, where with all the COVID restrictions in terms of getting to trial, that's even longer now. I mean, we're seeing cases that have been around for 3 years. But by the time you get to the end of that, a consumer will have spent $50, $100, $125,000 to replace a $50,000 roof. It doesn't make sense.
Correct. And that's the true concern. And often these are the issues are that the homeowners that most desperately need attorneys are the ones that don't have the wherewithal or the funds already in their bank accounts to pay for the roof replacement. So now not only can they not pay for the roof replacement, they couldn't afford to hire an attorney to try to help them get the money to replace the roof. So they're doubly out.
So I think what we're seeing a continued attempt to erode, if you will, what consumer protections that are out there that can protect the citizen in Florida from an insurance company that engages in practices that are less than in good faith. Is that fair to say?
I agree. And like I mentioned earlier, what's interesting to me is nowhere in the bill does it tie putting in this roof replacement schedule that limits the payments made out to an actual reduction in premiums.
Right. And I mean, we saw it a couple of years ago when the legislature took out the ability for a homeowner to assign his insurance benefits to a roofing company who would have better capability to fight the insurance company. That is not necessarily gone, but they've regulated it so much that it's nearly impossible to do. And what concerns me is that we're continuing to see that type of erosion in terms of protections for these consumers when they have to face insurance companies. And we've both seen cases where, for example, they claim what is clearly wind damage, okay, meaning the ridge caps or the hip caps have been
Lifted by the wind.
Lifted by the wind, right. We've seen that happen, and insurance companies blame it on birds sitting on top of the roof. I mean,
Things like
it's
that,
silly.
or just commonly what I see very often is just normal wear and tear.
All the time.
And so all of a sudden, normal wear and tear on a roof that should have lasted for 30 years but is 12 years old and is leaking, now they're not responsible because it's normal wear and tear, without any explanation for why the roof is lasting half of its expected life.
Or some consumers are glad to hear from their insurance company, by the way, you're covered. But unfortunately, because there's always the but unfortunately, it doesn't cover your deductible. So we're not paying anything. You're paying it all. We see those types of things all the time. And at that point in time, really the only thing a consumer has in their pocket is the ability to go see counsel and know that their counsel is going to get paid and that they're not going to have to pay it out of pocket. Is that
Right. And as I recall, the big change with the assignment of benefits laws, what they did is if someone receives an assignment of benefits like a roofing contractor, then they're not entitled to recover their attorney fees if they sue. So that's what had been going on, is the roofing contractors and other types of restoration contractors were using those types of assignment of benefits to ensure that if they were correct and they prevailed, not only would the homeowners get their damage repaired to the home, but the roofing company will be able to recover the attorney fees, and that's what enabled them to hire attorneys. But when they changed the law to say that you won't be able to recover any attorney fees whatsoever in that situation, it essentially was a death knell for assignments of benefits.
Well, what I'm going to suggest to our viewers is this: get in touch with Senator Brandeis, get in touch with your local legislator, let them know that you appreciate the protections that have been put in place for consumers for the last 50, 60 years, and that you want those to stay in place, and that as we approach the hurricane season in 3 or 4 months, that you'll be watching this particular bill to see what happens with it.
I agree. I think that's a good idea, in a way that our elected representatives make sure they're protecting their constituents, who are the property owners and homeowners here in Florida, and not looking out the same way for solely the interests of the large insurance companies.
All right. Thank you.